Appeal in the matter of various Eateries, Trading Limited and Allianz Insurance plc.
Morning, my lord. I appear for Allianz with my learned friend Mr. Killen, and my learned friend Mr. Mackay, King's Counsel, appears with Mr. Paul. My lords, this is an appeal from the judgment of Mr. Justice Butcher. Various eateries have claimed various business interruption losses under their policy, with Allianz arising out of the COVID-19 pandemic. As your lordships will have seen, the judgment answered various preliminary issues in relation to coverage, causation, aggregation, and limits. Various Eateries was one of 3 cases heard by the judge relating to the same wording, the others being the Stonegate, Pubs and Greggs matters. The judgments were handed down at the same time and cross-refer to each other. There were appeals in those cases as well, but as your lordships will be aware, those cases have now settled. Allianz appeals with the permission of the judge on 2 grounds. First, aggregation, and in particular, whether the losses aggregate to events in Wuhan or on the introduction of COVID-19 into the vicinity, the UK. And secondly, on the proper construction of the scope of cover under the Prevention of Access and Enforced Closure clauses. Various Eateries have filed a respondent's notice in relation to Allianz's appeal, which I'll deal with as it arises. Various Eateries appeals with the permission of the judge on 1 ground, namely whether aggregation should be on a per premises basis. Various Eateries also seek permission to appeal in relation to 2 more grounds, namely whether the judge was wrong to hold that there will always be at least 1 single business interruption loss, and whether the judge was wrong to hold that renewals, immaterial changes and relaxation of government measures are not to be treated as separate single occurrences for the purpose of single business interruption loss. So Lord, your lordships should hopefully have the core bundle and 2 supplemental bundles, 3 bundles of authorities, and hopefully a timetable which was circulated at the end of last week. As your lordship will see from that timetable, the plan subject to your lordship's direction is that I will open Allianz's appeal. My learned friend Ms. Mackay will respond to the appeal and open her appeal and application for permission to appeal. I'll reply on my appeal and respond to various Eateries' appeal, and Ms. Mackay will then reply in relation to her appeal. Your lordship will see that we have transcribers. I don't know if your lordship is content to have breaks.
Well, I was about to say, given that we have transcribers in court as opposed to a remote, which is sometimes the case, much preferable to have them in court. We'll have a 5-minute break at about 12. So if you can find an appropriate moment, and then about the same 3:15, if that suits.
Well, I'm great. Now, I'm conscious your lordships will of course have read the judgment, but I just wanted to make a few introductory points before turning to the question of aggregation. Your lordships will have seen that the policy is written on the Marsh resilience wording, and we can find that in supplemental bundle tab 1, page 1. Now this is wording that was considered in the FCA test case, where it was referred to as the RSA 4. Exactly, and my Lord the Chancellor obviously dealt with it in the divisional court.
Was the one on which vicinity was given a different meaning?
Exactly.
In a sense.
Exactly.
A critical point for present purposes, isn't it? Okay.
And it's a wording that is used for a range of insureds, for certainly SMEs, and SMEs, your lordships will recall, is any business up to about 250 employees or with a turnover of 50 million, to very large insurers, as is clear from the Greggs and Stonegate matters. The judge described it correctly as an off-the-peg wording in paragraph 7 of his judgment. It's used at least by 7 insurers in the market. and it's made up of both a policy wording and a schedule. And if I could just take your lordship to some of the key clauses, and I'll come back to them as appropriate. If we start first in the wording, if your lordship turns to supplemental bundle page 6, one sees there the heading insuring clauses. Section 1 is material damage. If one turns over the page to page 7, one sees there the heading business interruption loss, and 2.1 business interruption loss arising from property damage. But if we move on to what we're concerned with, 2.3, business interruption specified clauses, and the particular covers that we are concerned with in this case are 2.38, cover for in the event of interruption or interference with the insured's business as a result of notifiable diseases or other incidents, which is a defined term, and I'll come back to that later. But also occurring within the vicinity of an insured location. That in fact encompasses two of the elements of clause, both the enforced closure aspect of the clause, because of the definition of notifiable diseases, and the more pure disease clause aspect. If one then looks at 2.3.12, prevention of access non-damage, again a defined term, there is also cover in those circumstances. So there are essentially cover for disease, enforced closure and prevention of access. If your lordship then turns to page 27, which is within the definitions, I'll just take your lordship to a few of the key definitions. Definition 46, insured's business means the business undertaken by the insured as described in item 1 of the schedule, which we will look at shortly. And if your lordship goes down on the same page, insured locations. Insured locations means all locations and sites owned, occupied or utilised by the insured, of which the insured has assumed responsibility for the purposes of the insured's business, etc. If your lordship then turns to page 29, we see there the definition of notifiable diseases and other incidents. And there is a set list. Obviously, COVID was not on that list, but it was added. And your lordship can see under 69.2, it includes any additional diseases notifiable under the health protection regulations where a disease occurs and is subsequently classified under the health protection regulations. Such disease will be deemed to be notifiable from its initial outbreak. I mentioned that earlier that notifiable diseases and other incidents also included enforced closure, and we can see that on the right-hand column under 5, notifiable disease and other incidents means defective sanitation or any other enforced closure of an insured location by any governmental authority or agency or a competent local authority for health reasons or concerns. There is an endorsement, in fact, in relation to this provision.
Pretty clunky wording.
It is clunky wording, one might say.
It assumes that it's really defective sanitation which leads to an enforced closure, I suppose. We're not concerned with that.
We're not concerned with that, and indeed it's obviously been accepted that it can be wider than that, but it does have it's an odd wording. I would certainly accept that, but it's accepted for present purposes that this clause, it can be triggered as a result of government closure orders as a result of COVID. But just for your lordship's note, tab 5 of the supplemental bundle, page 96, has a endorsement in relation to this provision. It's not one that is relevant for any of the points that we're discussing now, and it's also quite difficult to read because it's in quite small text. That's why I took your lordship to the standard endorsement, just so your lordship is aware that this is in fact been replaced. But not for relevant purposes, any material changes. If we can return back to the policy and go to page 30 of the definitions, we see under definition 87, prevention of access, non-damage means, and then there are a number of different definitions. The one that we're concerned of here is number 2, the actions or advice of the police, other law enforcement agency, military authority, governmental authority or agency in the vicinity of the insured locations. And then if we jump to the end, which prevents or hinders the use of or access to the insured locations during the period of insurance. And then if we turn over 2 pages to page 33, or 3 pages, 33, we have one of the core definitions for today's appeal, the single business interruption loss definition. At 105, single business interruption loss means all business interruption loss and business interruption cost and expenses, excluding etc., and any amounts payable under extensions that arise from, are attributable to, or are in connection with a single occurrence, except in respect of cyber events, earthquakes, floods, storms, and riots, civil commotion, and acts of malicious persons. And just so your lordship is aware of it, if one looks under 2, there is a aggregating event or a single business interruption loss definition for cyber events, which is differently phrased, which is phrased by reference to connection with a single originating cause, just as a matter of contrast. I know it's a point that my learned friend makes.
And then there's a separate riots.
And then there is the earthquakes, floods, storms, and the sort of 72 hours clause.
Covers the Man of Lexington point, doesn't it?
Yes. And again, for completeness, if one turns the page to page 34, one sees a very similarly worded single business interruption, single property loss definition at definition 105. 106, my lord, yes. And if we turn then to the final page of definitions, page 35, we see there the definition of turnover, which is a point we'll come back to later. Turnover means the money paid or payable to the insured for goods sold or services rendered in the course of the insured's business at the insured's location. And Lord, if we now then turn to the schedule, which is behind tab 5, and turn first to page 73, item 1, policy details.
Just before we go there, vicinity in this case means
England or the
United
UK.
Kingdom?
I mean, that wasn't entirely clear from the decision, but in this case, it doesn't matter because various eateries only operates within the southeast of England. It certainly means England, and it could mean the UK. Item 1, policy details. One sees their details of the policyholder. Insured's business, 5 or 6 items down, operating a chain of Italian restaurants providing eat-in and limited takeaway of food and beverages.
Is it the same? It's the same company, is it? It was known as Strada Trading.
Yes, but as I understand the description, it used to have more businesses and operates primarily.
The business in 2014 or 15.
Exactly, my lord. So it's now 10 restaurants. It was previously, I think, 40 or 42 restaurants. And some of the brands are no longer the Strada brand; they're the Copper brand or a variety of other names. There are still a few Strada restaurants as well under that brand. And if your lordship will see the if one turns the page, one sees the operative clauses, and one sees in particular that there is cover for business interruption specified clauses. If one then turns to page 75 and 76, one sees item 3, declared values and limits of liability. On the first page, one sees declared values in relation to material damage. On the second page, page 76, one sees declared values business interruption. Now, the first part of that, declared values business interruption up to limits of liability, is in fact restated in an endorsement which is on page 97, which I'll take your lordships to.
Okay.
But for present purposes, if I could just point out the limits of liability. So one has limits of liability being the total value, insuring clause 2.1, that's the material damage business interruption, insuring clause 2.3, and one can see there in relation to 1 to 6, there is a total single business interruption loss limit of some 48 million pounds. One will see that's in fact the total declared value for business interruption loss when we go to the endorsement. Under injury to essential personnel, it's a limit of 250,000, loss of attraction 1 million, and notifiable diseases and other incidents, it's 2.5 million. And under 12, prevention of access non-damage, it's 500,000, all expressed by reference to any one business interruption loss. And if your lordships turn to page 97 now, which is one of the endorsements, your lordships can see that the declared values for business interruption are restated there by reference to what are items 1 and items 2. And there's first a reference to the estimated annual profit for the two items 1 and items 2 properties. And then there are different indemnity periods for item 1 and item 2 properties. First one being 12 months, item 2 being 24 months. And then there is a total declared value by reference to the percentage uplift, which comes to a total of just over 48 million for both items 1 and items 2. And at the very end of the page, one sees how the different premises have been allocated either as item 1 or item 2. Now, what I take from that very quick introduction is simply to underline that this is a off-the-peg standard wording, some 44 pages of policy, detailed definitions running to some 17 pages and 121 definitions, and a long and again detailed schedule. And we say that will become relevant when one looks at the approach to construction, which we'll come to. As I've already mentioned, the insured operates businesses focused in the southeast of England. I think it is, as said, some 10 restaurants and bar concepts. Various Eateries cases that it started suffering loss no later than the 27th of February 2020. We don't need to look it up, but the reference for your lordship's note is Core Bundle 19, page 29, paragraph 17. I think that the page number may be wrong, I will check that. But it's in the voluntary particulars. By comparison, for your lordship's note, the government advice to avoid non-essential contact was not first made until the 16th of March.
Yeah.
And that in relation, and avoiding restaurants and bars, etc. So the various Eateries cases, they started suffering loss materially before that point of time. Now, my lord, there's no dispute that various Eateries did suffer business interruption loss. Payment has been made of one single business interruption loss limit of 2.5 million. and there is agreement that they are entitled to additional costs of working and claim preparation costs on top of that, subject, I think, still to certain elements of proof. The various eateries case, however, is that as a result of the number of single business interruption losses available, they are entitled to recover their full loss of, I think, £16 million. And Lord, with those brief words of introduction, if I can turn to the first ground of appeal, namely the question of aggregation. And the question here is whether the judge was wrong to conclude that the business interruption losses did not aggregate with the initial emergence or appearance or start of the virus in Wuhan, or indeed by reference to the introduction of the virus into England, and only instead aggregated by reference to certain government action materially later. Now, the judge dealt with this question at paragraphs 82 to 103 in the various eateries case, but he also dealt with it in more detail in the Stonegate judgment to which he cross-referred, which is paragraph 75 to 192. For present purposes, if I just introduce the key elements in what I say the judge's analysis, so that I can deal with them, and if I can do that by reference to the various eateries judgment, which is at tab 15 of the core bundle. Paragraph 92, page 263. So having set out the various options that were put forward, he sets out his conclusions at 92. Thus, in this case, as in that, I would reach conclusions that an informed observer would have considered that the initial human infections could be described as a single occurrence, 2, that the outbreak of the disease in Wuhan thereafter was not a single occurrence, and 3, none of the virology options in that case would have been regarded as a single occurrence. He made no finding in relation to whether the first relevant human-to-human transmissions amounted to a single occurrence. He accepted in paragraph 93 that all the Wuhan events would be connected with the claimant's losses for the purpose of the linking language. That's at paragraph 93 of the judgment. But he considered, as he had in Stonegate and in Greggs, that the events in Wuhan were too remote as a matter of geography, time, and causal relevance. And that's set out in paragraph 94. In terms of the introduction to the UK or to the vicinity, the judge didn't decide whether that amounted to a single occurrence, but he did make clear, and this is paragraph 96, that he didn't consider those events to be connected with various eateries losses, and that they were in any event temporally remote, even if less geographically remote. So in the light of the judge's reasoning, there are really 3 questions. The first is whether the candidates relied on by Allianz as amounting to an occurrence, or more specifically a single occurrence, were indeed single occurrences. The second is whether the introduction of the virus or the first transmission in the UK was connected with the loss. And thirdly, whether any such identified single occurrences were too remote. And I think it's very fair to say that the focus of the judge's reasoning was on the remoteness aspect, but obviously each of the elements is important. And what I plan to do is to start by looking at the relevant legal principles, most of which is unsurprisingly uncontroversial, And I can take most of the points fairly quickly.
Yeah.
But we do say one has to look at the question as a whole in order to reach the right answer. I'm going to focus particularly on the question of the correct perspective, what amounts to an occurrence, the question of remoteness, and the relevance of searching for what can be described as a meaningful or significant or defining explanation for what has occurred. I'll then go back to the policy and the SBIL definition by reference to those principles, and having done so, I'll look at the events in Wuhan and the perspective of the reasonable policyholder to hopefully persuade your lordships that the most meaningful occurrence was the emergence of the new virus in Wuhan. I'll then much more briefly deal with our fallback case relating to the introduction of virus into the UK. Look, just one initial point that I make, and I make it at this stage, and it may be that I return to it in reply. My learned friend says, well, really what we're criticising here is an evaluation by the judge rather than any error of law. Now, in my submission, it's a surprising submission in one way, because it is a point, of course, that the judge himself gave permission on, and readily gave permission on to all the parties. There was no hesitation on the basis that this was in fact simply an assessment. And we say that in fact, on analysis, there is nothing to the point, because the essential error of law, and we'll come to the detail, is that the judge has taken an approach to remoteness which is inconsistent with the express linking language used in the policy, and he has failed to step back at any point in considering the Wuhan options to consider as a matter of judgment what is the most relevant or meaningful explanation for the event. And I'll come to this in more detail, but just to be clear, we don't accept that the criticism here is really one of the evaluation. We do say we criticise the approach of the judge in dealing with the question of aggregation.
Can I just ask, do you mean that it is not an evaluative exercise to which we apply those principles? Or do you mean that applying those principles, the judge went wrong anyway?
I mean that I accept that there is ultimately an evaluative exercise, but he didn't apply the correct principles.
Yes, I see.
Now, Lord, the judge dealt with the question.
Is that he, as I understand the submission you just made, is that the judge's approach to remoteness, elevated remoteness, within this particular policy wording beyond what it merited, if I can put it that way.
Yes.
Given the looseness of the causal connection and words in connection with.
Yes. It's more that, so that's certainly part of my submission, that it's inconsistent with the express contractual language. But it's also a question of where one might say the analytical tools of looking for events, causation, and remoteness fit in to the overall judgment of exercise of selecting a relevant aggregating event. And we say that there is a danger, and it is incorrect, to apply remoteness without reference to the question of what is meaningful, what is relevant. And that's what, if one simply asks the question, is it remote as a matter of time and geography or causation, without first asking, is this a meaningful or relevant explanation, you will go wrong. And that's a submission we'll hopefully develop. But we say it's not just the causal language, it's the fact that remoteness isn't an independent test from the question of judgment. Remoteness inherently has an element of judgment within it, not just a question of temporal or geographic distance. Now, Lord, the judge dealt with the question of law at paragraph 88 of the various Eateries judgment. If one goes to it, one won't see much because, to be fair, he almost entirely cross-refers back to the Stonegate judgment, where he deals with it in much more detail, which and that's paragraph 78 to 90 and 101 to 116. And we set out the principles in our skeleton at paragraph 25. What I want to do for the purposes of this appeal is simply highlight 6 points I said most of which should not be controversial, but which we say all feed into the final analysis. The first is that the starting point is that aggregation clauses are to be construed in a balanced fashion, without a predisposition towards a narrow or broad interpretation. That's a point made repeatedly in the cases, I think most recently by this court in the Spire Healthcare and Royal Sun Alliance case, which I'll come to in a minute. And that's simply a recognition, of course, that aggregation clauses can apply to both limits and deductibles and favour either insureds or insurers. Secondly, in considering aggregation, language is key. And it's a point the judge makes and we make, and your lordship has the reference in the submissions to the Lloyd's TSB case where Lord Hoffman makes that obvious point. And for today's notice, the Authorities Bundle 2, tab 17, page 511 at paragraph 17. Now, that obviously ought to be an obvious proposition, but we do say one of the dangers here is an attempt to transpose dicta relating to very different language as having more general effect. And again, I'll come back to that. So it's an obvious point, but an important point. And it applies in the aggregation context, most importantly, both to what the unifying factor is and what the relevant linking language is between the unifying factor and the loss. Third, we entirely accept that referring to a unifying cause or originating cause will normally encompass wider unifying factors than a reference to an event or an occurrence. The latter, by reference to event or occurrence, requires something at a particular time, particular place, particular way, whereas the former obviously can include a state of affairs or something much more general. But again, the important point for present purposes is just to recognise that they can sometimes lead to exactly the same result. And that's we've given again the reference to the Lord Justice Waller's dicta to that point in the R.E. Brown and GIO case, Authorities Bundle 2, page 569, paragraph 204. Fourth, the question of occurrence is to be determined by reference to the informed observer in the position of the insured. And that's because perspective can be key to how one understands the position. And perhaps, just so your lordship has it noted up, it's obviously a very well-known example, but if your lordships turn to Authorities Bundle 2, tab 15, the Q8 Airways case, judged for Mr. Justice Ricks. Page 479. Where Mr. Justice Ricks quotes from the Dawson's Field Award.
Sorry, what,
479, right-hand column. And one can see from the left-hand column, 2/3 of the way down, that the judge is referring to the award. Halfway down on the right-hand column, one sees the consideration of the question of occurrence and reference to the fact that one can take lots of different examples. And if we take it halfway down from that, 2/3 of the way down on the right-hand column, on which side of the line these is to be placed depends, in my view, on the position in which the person who has to make the determination is placed, and on the way in which he will therefore approach the question. The crews of a submarine and of ships which are attacked and sunk in a convoy would no doubt regard each attack and sinking as a separate occurrence. An admiral at naval headquarters might regard the whole attack and its results as one occurrence. A historian almost certainly would. An earthquake may have a number of tremors producing different damage at different times in different places. The victims would no doubt regard each tremor as a separate occurrence, but others might not. Whether or not something which produces a plurality of loss or damage can properly be described as one occurrence therefore depends on the position and viewpoint of the observer and involves the question of degree of unity in relation to cause, locality and time, and if initiated by human action, the circumstances and purposes of the person responsible. And my Lord, in fact, one sees that in some of the cases that we have in the bundle. And your Lordship we have in the bundle, for example, the Silversea decision, the A.O. Nisai decision and the Simmel and Gamble decision, which are all decisions which involve the 9/11 in one way or another. In Silversea, the question was loss perspective was a cruise company in the context of warnings given by the State Department, and it was all seen, and we'll come back to this, as effectively one defining event by reference to 9/11 generally. The I.O. Nisai case was a case of aviation loss following the attack on Twin Towers in the context of an XL reinsurance loss, where it was regarded as the attacks on the Twin Towers were regarded as two separate events, judgment of Justice Field, whereas the Simmons and Gamble case, which was a case relating to the reinsurance liability of the Port of New York's liability arising out of 9/11, both on the day of 9/11 and the subsequent cleanup, was there the attacks on the Twin Towers were seen as one event, being the attacks on the Twin Towers. Now, the relevant point here isn't really the analysis, and we'll come back to the cases. It's the point that it illustrates that the answer to the question of how many events may well depend on the perspective and the purpose for which you are asking the question.
Although the I.O. Nisai case, to come back to your previous point, was really a decision by Mr. Justice Field that the arbitrators hadn't gone wrong in law and were entitled to find what
No, I'd certainly accept that, and that may also be said about the Simmons and Gamble case to a certain extent. They are, there are appeals from arbitrators. But the relevant point for present purposes is really the illustrative one here of showing that perspective will change.
No, I appreciate
and that's
different point.
for present purposes. I'm not trying to draw a point of principle beyond that, other than illustrating that different perspectives will yield different results. The question of the relevant aggregating event. Lord, I'll come back, if I may, to the question of whether the perspective of that person should be by reference to the true facts, which is, as you'll know, something which is what Mr. Justice Rick said, and we'll see that, in fact, over the page. In fact, on page 480. Since your lordships are there, I might just ask your lordships to look at this now, so I don't need to take you back to it. Sorry, page 480 of Authorities Bundle, tab 15. I'm sorry if it's...
Is this still from Dawson's Field, is it?
No, this is actually Mr. Justice Rick's analysis thereafter. It's the second column, page 480, a few downs from the top. Nevertheless, the losses circumstances must be scrutinised to see whether they involve such a degree of unity so as to justify their being described or arising out of one occurrence. The matter must be scrutinised from the point of view of an informed observer placed in the position of the insured. I would suggest that, as in the case of analysing a situation for the purpose of deciding whether a constructive total loss has occurred, the scrutiny must be performed on the basis of the true facts as at the time, and not simply on the facts as they may have appeared at the time. And your lordship will see that's a point which Mr. Justice Butcher dealt with, because he didn't follow that approach. Now, as it happens, it doesn't directly matter in this case, but it is analytically important, we say, and it does have a relevance in terms of one of the points he relied on in support of that argument, which we say does need to be put in perspective. But I'll come back to that if I may.
Yeah.
Now, in terms of identifying that occurrence, the unities of time, cause, and place may be relevant, and they are aids or guidelines. And the judge accepted that they were aids or guidelines. I think my learned friend accepts that they're aids or guidelines. There perhaps is still a distinction as to how firmly one applies them and whether these guidelines become more of a straitjacket rather than a guide. We would simply underline that they are not to be applied mechanistically, but they are clearly helpful analytical tool for the court in deciding what's relevant. Now, The relevant unity for an occurrence will differ.
Are we
And
still on your fourth point, or have we moved
yes,
on?
well, we're on the fourth point. So at the moment we're dealing with the question of occurrence. So we're dealing with the scope of
Yeah.
what it amounts to an occurrence, and the unity that's necessary for identification of occurrence will differ. So the example that one can give, and I think was given below, is in Scotland, Copenhagen, where the judge, in considering the loss of the BA aircraft in that case, was happy to consider the war as being an occurrence. He said it was either the loss of the aircraft, the war, or the outbreak of war, and it was indifferent as to which it was. And I'll come back to that. It's paragraph 72 of Scotland, Copenhagen.
Yeah.
Now, the type of cover may also be relevant in identifying what should count as the relevant event. And again, if your lordship still have the KAC judgment, the Q8 Airways case open, one can see that on page 483. Left-hand column. And it's the point that Miss Justice Ricks makes halfway down the underlined part, having said there is unity of intent. Moreover, since the contract in question is one of war risks, the context is one in which it must be fair, if appropriate, to describe the relevant occurrence in broader as distinct from narrow terms. Now, Lord, all I take from that is the point that it's going to be context specific, peril specific. Now, the final point I want to take your lordship on the question of occurrence is what the Supreme Court said about occurrence in the FCA test case.
Yeah.
And if your lordships turn to that, that's in tab 12, Authorities Bundle 1, tab 12. Page 338. And there, Lord Hampden and Lord Leggett say a disease that spreads is not something that occurs at a particular time and place and in a particular way. It occurs at a multiplicity of times and places and may occur in different ways involving different symptoms of greater or lesser severity. Nor, for that matter, could an outbreak of a disease be regarded as one occurrence unless the individual cases of disease described as an outbreak have a sufficient degree of unity in relation to time, locality, and cause. If several members of a household were all infected with COVID-19 when a carrier of disease visited their home on a particular day, that might arguably be described as an occurrence. But the same could not be said of the contraction of the disease by different individuals on different days in different towns and from different sources.
Yeah.
Still less could it be said that all cases of COVID-19 in England or in the United Kingdom or throughout the world, which had arisen by any given date in March 2020, constituted one occurrence. So what one has there are extremes. So it's clear that the court is saying, well, an occurrence that involves multiple towns over days and weeks is not going to be an occurrence. The family situation might well be. It's not a defined purpose, a defined situation to where precisely the line goes. And that is something that one needs to look at from the relevant perspective for the purposes of the relevant clause. And the key distinction for present purposes, and I think it's a distinction my learned friend accepts, is that here, of course, the question was being asked for the purposes of coverage. This appeal is about aggregation, about pulling together a plurality of losses. And as such, we certainly suggest a broader approach applies. I mean, we would say whether one applies that wording directly, one still gets to the relevant occurrences, but when one is looking at the question of aggregation, it is certainly right that one can look at a broader range of matters, just like in Scotland Copenhagen one was looking at. It wasn't necessarily to say the outbreak of war, which was one of the options. One could say war. Now, Lord, turning to my fifth point, of key importance is the linking language between the event or cause and the loss. Most of these cases that are in the bundle relating to aggregation have language referring to arising out of. As your lordship saw in the context of the SBIL clause, we have arising out of, attributable to, and in connection with. And there's no appeal here by either side from the judge's finding that in connection with is wide language, which is not necessarily, and it involves only a relatively weak or loose causal connection. And that, we say, is entirely consistent, in fact, with the case which have considered this sort of language. It's obviously always going to be context specific, but your lordship will have seen the reference in our submissions to the Campbell and Conoco case, which wasn't an insurance case, but it was an indemnity clause case where I think Lord Justice Ricks described as the widest language more commonly comes across. Just your lordship's reference, that's Authority 6, page 88, paragraph 6. I don't think we need to go into it because there's no dispute about the essential point. Now, the importance is that wide linking language necessarily allows for a wide search. But the fact that there's a wide search doesn't mean that every event that you identify will be a relevant or a meaningful one. It just gives you a wide net. But conversely, and I'll come back to this, the fact that a clause invites a wide search with only a weak causal link means you can't effectively automatically disqualify an event with a weak causal link as being too remote. That, we would say, is inconsistent with the language. But of course, I accept there needs to be a selection. Whatever form of linking language you have, you may come up with a number of candidates. And the question is, which candidate is it? Now, sometimes it may not matter, as we'll see, which one it is, because they all lead to the same result. But where, of course, they would lead to different results as a matter of aggregation of the losses, then one needs to distinguish between them. And that takes me to our sixth and final point. After considering unifying factor and the relevant link language, it's necessary to consider remoteness or the absence of remoteness to help cut down the options. But this isn't a self-standing test. This is something that needs to be applied in the context of the language of the clause and whether any identified event is a meaningful explanation. It can't be divorced from the overall exercise of judgment. I mean, some cases talk about common sense, some talk about intuitive answer. And Lord, can I take your lordships first to the to Caudle and Sharp, the Court of Appeal decision in Caudle and Sharp. This was a case about aggregation in a reinsurance context of various professional indemnity, professional liability losses. And the language there was, the linking language there was arising out of. if your lordships can turn to page 99. And this was addressing a submission that arising out of should be interpreted in a loose way. If your lordships go to the first substantive new paragraph on the left-hand side on paragraph 99, and the judgment of Lord Justice Evans, in my judgment, arising out of should not be construed in this limited sense. First, because occurrence is at least capable of meaning the operation of the insured peril out of which the original loss arose, and that occurrence has itself arisen out of the relevant event. And secondly, because the hurricane in the paradigm situation referred to above is the proximate cause of the loss suffered by the original insured or the loss suffered by the reinsured. Some wider test of causation is therefore implied. There is no express restriction on remoteness, provided the loss or occurrence can be said to have arisen out of the event, but some restriction must also be inferred, as the Ice Age example suggests. And what we say one can take from that is the obvious point that we're looking here, when we're talking about the concept of remoteness, something which doesn't actually exist in the clause. But it is obviously necessary for the clause to work, to have some assistance in how to select events. But the analysis is that it is inferred into the clause, into arising out of. So it's a contractual question. It's not a rule of law that comes in from the outside to apply in this situation. It's simply an application of the contractual aggregating provisions. The other difficulty is, of course, saying that something is remote is a conclusion rather than any form of analysis. The question is, why is it remote? Now, Lord, in this regard, the judge below, as part of the legal analysis, referred to the Scotland-Copenhagen decision, Lord Justice Riggs, and it's worth going to that because there the judge does underline, or Lord Justice Riggs does underline the approach to be taken, albeit I underline at this stage, in the context of language there, which was arising out of language. Now, Scotland-Copenhagen is an authorities bundle 2. Tab 23. And if one starts at paragraph at 63, page 747.
Page
747, left-hand column, paragraph 63. As for causation and remoteness, it seems plain that the latter concept was used by this court as a tool to limit the otherwise infinite reach of the workings of causation. That is the function of the concept of remoteness in the law generally. It is, in other words, a legal tool used to separate out relevant from irrelevant causes. As often happens, however, the use of this tool is somewhat opaque. What the decision in Cordon and Sharp does seem to me to suggest, however, is that even though the causative link is looser than that of proximate cause, the courts will look to the nearer and more remote and more relevant cause than for a more distant one. Another way of saying this is that the causative link has to be significant rather than a weak one. So, Lord, the focus here is on nearer and more relevant, and this, of course, both in the context of arising out of, because Cordon and Sharp was arising out of Scotland Copenhagen is arising out of. But it's important to understand what's being said here, we suggest. It doesn't mean, as various eateries appear to suggest, that you simply choose the closer event in time. This is an aggregating clause. The aim is to treat a plurality of losses as one. And that would almost inevitably mean you always end up with, referring to the proximate cause, which Lord Justice Ricks equally makes clear that one is not looking at the proximate cause and wouldn't have any value. It's simply a reflection in the context of choosing between events that you're looking, the focus is on the more relevant, and near in that context by reference to more relevant. If anything, we would say it's a sort of tautologous point, nearer and more relevant rather than more distant. It's not telling you that a proximity of time is itself the answer. Otherwise, the reference to relevant wouldn't need to be there. It's also important to understand that it's a tool. It's not as such a strict test. Well, if we turn then to paragraphs 67 on the same page, I revert to Mr. Boyd's 4 principal submissions. The first was the causal link expressed in the phrase arising out of is a weak one, and that therefore, and possibly in any event, there was nothing that occurred after the initial invasion and capture of the airport that outweighed the significance for the purposes of causation. In my judgment, however, there is nothing in the authorities to support that submission. And then he refers to the Dawson's Field case, and he refers to the concept of aggregation arising out of one event. And then picking up 2 or 3 lines from the bottom, in this connection, I would refer to Lord Hoffman's substantial contribution in recent years to an understanding of what lies behind the court's intuitive judgments on issues of causation. Lord Hoffman emphasises that it's not possible to give an informed answer to a question of causation when attributing responsibility under some rule without knowing the purpose and scope of the rule. In the present context, the purpose and scope of the rule is to be found in the concept of aggregation inherent in wording such as arising out of one event. A plurality of losses is to be regarded as a single aggregated loss if they can be sufficiently linked with it. The aggregating function of such a clause is antagonistic to a weak or loose causal relationship between losses and the required unifying single event. This is the more easily seen by acknowledging that once merely weak and causal connection is required, there is in principle no limit to the theoretical possibility of tracing back to the causes of causes. The question is therefore, in my judgment, becomes, is there one event which should be regarded as the cause of these losses, so as to make it appropriate to regard these losses as constituting for the purposes of aggregation under the policy one loss? So, Lord, the first point to note is the one I've already made, which is obviously this is all in the context of arising out of. The second is to underline, in a way, the conclusion, which we say is the relevant question, which applies more generally, which is there one event which should be regarded as the cause of these losses to make it appropriate in the context of the perspective of the policyholder and in the context of the specific clause. So that's what one can take, we say, from what Lord Justice Ricks says about very different linking language and apply here. Finally, just on this point, if your lordship goes to make good this point that it is a question of overall judgment in this exercise, if you turn to page 750, paragraph 81, the 4th submission is the test of unity is inappropriate in the case where one event leads to both immediate and total losses and other total losses more distant in time. And then over the page, I disagree. The submission highlights the issue in this case, but also begs the question, are the losses to be aggregated as all arising from one event? That question can only be answered by finding and considering all the relevant facts carefully, and then conducting an exercise of judgment. The exercise can be assisted by considering those facts not only globally and intuitively, and by reference to the purpose of the clause, but also more analytically, and rather by reference to the various constituent elements of what makes up one single unifying event. It remains an exercise of judgment, not a reformulation of the clause to be construed and applied. And in my submission, that is an element that the judge did not do here. When one looks at what the judge did, it was ultimately a mechanistic analysis without standing back and saying, well, actually, what is the meaningful explanation for what occurred here? Now, Lord, of course it's right to consider distance in geography and time. Why is that relevant? Because typically, distance in geography and time will give an opportunity for other events to intervene, which may be more significant.
The judge had other points in mind, though, didn't he? For example, there was a point about, when one's still in Wuhan, if I can put it that way, there was an issue about whether this particular disease was going to become an international pandemic, or whether it was going to stay within the Far East, as SARS had in 2003. And there was an issue, I suppose, in relation to when it came to the UK, about whether there was ever going to be a lockdown at all. We had all that stuff about herd immunity that's currently being debated before the inquiry.
Yes.
And it could have been the case that our government decided to go the same way as Sweden, in which case, it might have been losses, but they would have been different losses.
Yes, well, that's a point that I'm
not sure that it's fair to say the judge adopted a mechanistic approach to remoteness, and that's why one of the reasons why he thought that the outbreaks in Wuhan, if I can put that, or the Wuhan events, if I can put it that way, neutrally, were too remote.
Well, your lordship is right that
they weren't really causative.
Exactly. So the judge considered three elements. I considered time, geography, and causative remoteness. I'll deal with all those specifically when I come to the Wuhan points, because your lordship's quite right. He did make those points. We say none of those points really alter the fact that it was simply the workings out of something that had already been set in motion. But I'll come back to that. And in a way, your lordship's example of Sweden, we would say ultimately underlines why focusing on government action is not really the meaningful explanation for what occurred. Because losses would have occurred whether one went down the Swedish route or the English route. And if one then says, well, what's the meaningful explanation? One suddenly says, well, actually, maybe the government explanations aren't as meaningful, when most of those losses, or many of those losses, would have occurred anyway. But if I may, I'll deal with that on the actual facts as they come on, when we get to the Wuhan situation.
Well, there are pleaded losses, as you said earlier, in relation to the period before there was any government action.
Exactly.
And therefore, the question might arise, I suppose, whether there was any SBIL applicable to those losses.
Yes.
I don't suppose that will matter unless they exceeded 2.5 million, but we're not at the stage of quantifying
Yes.
yet, so I suppose it's a possibility.
Yes, exactly. There's the analytical question, and I think your lordship is right. Obviously, one answer is that I'm right, but only up until government action. But it may not make any difference because the losses prior to government action will be sufficiently.
Did the judge actually deal with that, or was it such a matter that was argued before him?
No, Lord.
The point about the period between the 27th of February and the 16th.
No, because the parties were going on their effectively their primary positions, which were really Wuhan coming into the UK or government action. And obviously there are one of the difficulties with aggregation.
Not focusing on the impact of that on the losses, because obviously this was a trial of issues.
Precisely. So there wasn't a need to consider the specifics. And obviously one of the difficulties, we'll see this, is of course you can express the same point, or broadly the same point, in many different ways. And I'll come to this later, but there's a lot of dancing on the head of a pin in relation to how you can describe, is it MRCA first transmission outbreak, initial outbreak, and we will say, well, none of that really matters. The question is whether there is in essence a decision which is made, an event which is the meaningful explanation in a sort of generic sense for the perspective of the policyholder. Again, I will deal with that.
Okay.
Now, Lord, I think one of the examples we give, and I think we give this in the in our written submissions, is that the fact that the event relied on is a bit further back in time and more geographically remote can't, as such, mean it's too remote without more. Simply going back a bit in time or being a bit further away can't be the answer. I mean, an example of that is perhaps the Midland Main Line case, where the proximate events were the individual emergency speed restrictions that were placed on the railway following the Hatfield derailment. But for the purposes of the deductible, the judge had no hesitation, Mr. Justice David Steele had no hesitation saying, well, the relevant event is in fact the derailment, even though the derailment didn't as such cause all to the emergency speed restrictions all over the country. There was a disconnect between the two. But it's a different question. You're not asking for simply the most approximate in time. I mean, another example, if one goes back a bit more in history, if one thinks of the Mount Tambora eruption in 1815 in Indonesia, which I think was the biggest eruption in sort of 10,000 years, and which led to crop failures the following year all over the world and in Europe. The mere fact that it happened in Indonesia, and the mere fact that losses were suffered in Europe or in England because the summer never came, wouldn't alter the fact that the meaningful the explanation for this is the eruption the previous year far away in a different country. And the question is why? Why is that the relevant question? And that's really, we say, because it's tied up with finding an event or a cause that provides a meaningful explanation for the loss. And that's a point we say is picked up in the recent decision of this court in Spire Healthcare, which is at tab 25 of bundle 2 of the authorities.
Is that the origin of the meaningful explanation phrase, or does that come from somewhere in this case?
It's certainly the one where it's the most used. I mean, to be fair, the judge uses it in other contexts here. It's certainly the one where it's most used. I mean, your Lordship will see we also refer to defining event, which I think is a phrase used by Mr. Justice Tomlinson in the Silver Sea.
I just wondered if meaningful explanation was a phrase which we find in earlier cases, because I didn't notice it in my reading
I have to be offhand. I can't say that I have noticed it as an explanation in earlier cases. What we say is it reflects as the judgment.
Just tell me about, sorry, just going back a second, which is the case in which the Indonesian eruption is referred to? I don't think I've come across it previously.
I'm not sure that's referred to. I'm not sure that's referred to in a case. I think, to be fair, it may have been a point that Greg's made below. As one of the examples they gave, that's maybe where it's come from in my head. But it's the Mount Tambora. So yes, I don't think there were any specific insurance losses related to it that I'm aware of. There may have been, but it's more the point of looking at trying to identify what one says is the key event.
Yeah. Okay. So Spire Healthcare.
So Spire Healthcare, tab 25. And this was an appeal relating to the surgeon, Mr. Pattinson, who performed surgeries for a variety of reasons, but negligently and without the proper consent of patients. And the private hospital in which he worked settled those cases. And the issue was whether there was a distinction between the types of cases that he was dealing with, and such that they should actually be treated as two events or one event. And the judge below considered that the types of cases he was dealing with were materially different, because the first related to negligent performance of mastectomies and exposing them to recurrence of cancer, and the second was mainly private patients who'd undergone unnecessary surgery when the surgeon had dishonestly represented test results or exaggerated the risk. So there was arguably a distinction. The judge held that there was a relevant distinction for aggregation, and the Court of Appeal didn't. Important to note, this is wide unifying language, it's originating cause.
This is all attributable to one source or original cause.
Precisely. So the unifying factor here is much wider, but the relevant exercise in how to choose, we say, must apply equally, because where there is a choice, the court needs to decide how to exercise that choice, and we say the guidance in the Spire healthcare is therefore helpful. Whether one calls it the most relevant cause or meaningful or significant or defining, in my submission, again, doesn't really matter.
Well, I can see your argument for saying, if you had that wording, you'd be on much stronger ground for saying that what happened in Wuhan was the original cause or the source.
Of course I would, but Lord, what I'm not. But the purpose for taking your lordship to this case is not an analogy of here there was aggregation. It's more, what are the tools to be used for choosing?
Okay.
And we say that in that regard, the guidance is helpful. If your lordship turns first to paragraph 24, which is on page 767. Just above E, paragraph 24. In searching for the unifying factor, one must not go so far back in the causal chain that one enters the realm of the remote or coincidental causes, which provide no meaningful explanation for what has occurred. So what I take from that is, what is remote in this context? It is an explanation that provides no meaningful explanation for what has happened, in the context always of the language. So if one takes it in stages, if one has a narrower unifying factor, you'll have fewer candidates that are available in the first place. So for example, if there is no event at all, you won't have there simply obviously can't be anything to aggregate around. You then look at the linking language. The linking language is either narrow or broad and allows you to do a narrow or broad search. The results of that search then give you potential candidates, and it's from the candidates that are available from the contractual language that you then choose the one that provides the most relevant or the most meaningful or the most significant explanation. If one turns back, turns then to page 770.
Yeah.
That's how you put it. So you might have, I suppose, having made your choice and come up with a number of possible choices, you might think that several of them could be regarded as a meaningful explanation, but you're looking for the one which is the most meaningful.
Yes, because there has to be a decision as to what the answer is. Now, the answer can't simply be to say, well, you look at the more recent, because the more recent may not be the most meaningful. So on the Mount Tambora example, clearly the weather patterns would have been relevant for the effect on the climate next year, I assume. But one would say, well, that's still overtaken in terms of significance and meaningfulness from the perspective of the farmer in England or wherever, by the fact that there was one thing that caused all of this, which was the original eruption. So, Lord, if we pick it up on page 770, one sees there just above B is the court's analysis of why they aggregate, Lady Justice Andrews, based on a pattern of deliberate and dishonest behaviour by one individual who operated on hundreds of patients over 14 years in the 2 private hospitals run by Spire, with cavalier disregard for their welfare. There may be cases in which, on the facts, the behaviour of one individual will be too remote or too vague a concept to provide a meaningful explanation for the claims, but this is not one of them. As a matter of ordinary language and applying the principles applicable to aggregation clauses expressed in these wide terms, it seems to me plain that any or all of Mr. Patterson, his dishonesty, his practice of operating on patients without their informed consent, his disregard for patients' welfare, can be identified either singly or collectively as a unifying factor in the history of the claims for which Spire were liable and negligent, irrespective of whether the patients concerned fell into Group 1 or Group 2 or both. None of the factors which are identified could be described as falling within the realm of remote or coincidental clauses, which provided no meaningful explanation for what happened. Now,
That's why I was asking you where the phrase came from, because as you've shown us, Lady Justice Andrews has used the phrase meaningful explanation 3 times,
Yes.
or possibly more, as a decisive consideration in her analysis. And I just wondered whether it originates in this case or came from somewhere else.
My lord, I will be correct if I'm wrong. I think it does originate in this case. What you have elsewhere is language such as, and I'll take your lordship to it, a decision the Chancellor knows, the Silversea case, where Mr. Justice Thompson, in a slightly different context, uses the word defining event. There are references to significant event or relevant. In my submission, they're all doing the same thing, is the identification of what Lord Justice Rick says in Scott and Copenhagen in paragraph 81 or 82, where he says you've got to step back and look at it globally and intuitively of what does this aggregate around. And in doing so, you can't ignore the significance of the event.
And you're really dealing with two, so we'll have a break now in a moment, but it seems to me you're really dealing with two different issues which arise in these cases. One is the sort of case like Corden and Sharp, I suppose, where the issue really is there one cause or one event or one occurrence in circumstances where there's only one candidate put forward, and the conclusion reached in that case is no, there were 32 separate events, or I can't remember which wording it was. It doesn't really matter. And the other sort of case is the case like the present, where you've got a number of candidates for being an occurrence, and the judge indeed concludes that there are a number of candidates to be an occurrence. But then he has to decide which is the most causative, or which is the most meaningful, or whatever the right adverb is. And he uses remoteness as a tool to reach the conclusion that he reaches. Speaking for myself, it seems to me that's an evaluative exercise rather than an error of law. But
in my submission, the essential question is how you do it. I mean, obviously, there is an evaluative exercise in there, as in, once you get to the question of is it the most meaningful, that is an evaluative exercise. In my submission, that's not what the judge has done, because what the judge has done is he has specifically looked at it through the prism of time, geography, and causation. He's not done the step back to the global intuition or the exercise of judgment or the reference to meaningful or significance. And by doing so, we say that's the error. And in particular, by saying, for example, on causation, that you say, well, actually, there is effectively, it's too remote from a causative point of view when the contract itself has expressly said you have a wide search. We would say is an error of principle, not just an error of evaluation. But
right,
conscious
should
of
we
time.
have a break then for 5 minutes, please? Thank you.
Guys.
Guys.
Lord, the other point I just want to take from the Spire healthcare case, just to underline, is that there was no issue about having multiple different candidates. It didn't really matter in that case, as the Lady Justice Andrews said, which of those you identified of the various candidates of dishonesty, whether it was Mr. Patterson or the period of time. And indeed, that's similar to Scott and Copenhagen, where Lord Justice Rick said it didn't matter whether you described it as the war or the outbreak of the war or the loss of the aircraft, they all led to the same result. That's just irrelevant for a point that I come to later. Now, Lord, the Silver Sea case, if I could just take your lordships quickly to that decision of Mr. Justice Tomlinson. This was claimed
That's
by...
probably one as well.
Yes, exactly. Tab 14, bundle 1. And this was claimed by cruise liners for cancelled cruises following 9/11 in reaction to State Department or similar advisories.
Yeah.
And the relevant parties want to take your lordships to was at page 456, paragraph 66, when the judge deals with the application of the relevant deductible. And perhaps I'll just ask your lordships to look at paragraph 66, and then I'll just highlight the relevant bit.
66.
Paragraph 66 on page 455. Lord, the key bit that we underline is the bottom of page 455, where there are multiple warnings arising out of a single defining event at any rate of the magnitude of 11th December. It seems to me to call to common sense and what the party's intention must have been to regard those warnings, or at least those within the 6 months of the event, as a single occurrence, since they all arise out of the same set of circumstances, both actual and threatened. And Lord, again, what I take from this is an application of the intuitive principle. It's obviously not directly applicable, but it is, in my submission, correctly analysing the approach, which is to say one looks at perspective, one looks at the context of the clause, and one takes an intuitive answer. 9/11 was, in that sense, a relatively easy answer in this context. It was the defining event. And that is essentially what I'm saying here. The defining event, if one stands back at the time of aggregation, is the start of it. And perhaps just in answer to my Lord the Chancellor's point earlier about the causative steps, and that there were so many extra steps that had to take place, one has to remember that the question of aggregation, as the judge said, and as Lord Justice Rick said, is to be considered as at the time of the aggregating event. So you're not looking at the question in Wuhan at the end of December, what's going to happen to this? Is it going to turn into a pandemic? You're looking at it at the time that you're aggregating the events, which is not going to be earlier than the losses are suffered, when the pandemic's already been declared or is about to be declared, and the losses are being suffered. So a lot of those causal uncertainties, in a way, become irrelevant, we would say, when one's looking at it in retrospect, and one's saying, well, actually, in retrospect, what was it that matters? What was the defining event? And it may become much more obvious to say this was something important. It was the beginning of the virus. Nor the other example, and I'm conscious of the time, but I'll just give your Lordship the reference. We refer to it in the written submissions, is the decision of Mr. Justice Cook in the Simmons and Gamble case, where the question was aggregation of injuries suffered by workers in the hours, days, weeks and months, and possibly years after the World Trade Center attacks. And again, an appeal from an arbitrator's decision, but they were held to aggregate around those attacks. And again, it's simply an indication of the flexibility of aggregation. I mean, in that case, there was obviously alternative arguments that respiratory problems had been caused by the failure to provide protective equipment, etc. Again, why is it an intuitive answer that you go back to the attacks? Well, because it's the defining event, it's the key event, the meaningful event. So we do say that insofar as the judge, as we say, applied effectively a separate test, or effectively applying remoteness, but without reference to the question of meaningfulness or significance, or stepping back to carry out the intuitive analysis, that was an error. It is not just right to look at it in terms of time, geography, or causative steps, and to say, well, if you fail to satisfy those requirements, you never get to the judgment or the exercise of judgment or meaningfulness. You look at the question of meaningfulness, perspective, and clause in order to decide whether something is too remote. It's the point in paragraph 81 of Scott and Copenhagen, looking at it both analytically but also globally and intuitively. And Lord, I said I'd come back to the question of whether you should assess this by reference to the perceived or the true facts. The judge held at paragraph 99 that of the Stonegate judgment that it should be by reference to the perceived facts of the reasonable policyholder when making the decision to aggregate. Now, this is not a point that makes a difference in this case, we say, because we say the answer is the same whether you look at the true facts or the perceived facts. But it obviously is relevant analytically, and it also touches upon a point that various eateries make, which that it's legitimate as a part of construction to prefer a construction that allows a quick decision in relation to a business interruption indemnity. And that was a point that the judge relied on. This is a reference to the Australian case of Marrickville. Now, we say that Lord Mr. Justice Ricks was right that you should look at this on the basis of the true facts, and I've given your lordship the reference to that. It's consistent with what Mr. Justice Field appears to have assumed in the Newey case, albeit he doesn't deal with it explicitly. It's paragraph 27, where he refers to the true facts of 9/11. But the key reasons we say why you look at true facts is that the wording of the SBIL itself invites a consideration of the position as it actually is, not as it's perceived. It's simply, is there a single, does it arise out of, is it attributable to a single occurrence, not as it's perceived in any specific time. And we say it's no different from other clauses as to whether there is an insured event, has in fact occurred, or whether an exclusion applies. You look at the position on the basis of the true facts. And it becomes particularly odd and difficult to try and prove facts as they stood at a particular point of time, especially if there's a debate about which point of time you should take. Because the judge recognised that the relevant time for assessing aggregation wouldn't necessarily be when the losses first start. It can't be before then, but it wouldn't necessarily be then either. And in which case you may have a continuum spectrum of knowledge which changes over time. Clearly, you can often reach a decision pretty quickly on aggregation, but it's a strong thing to say that an insurer or an insured can't rely on the true position. What if the insurer policyholder believe there's a fact, in fact a single event, but simply can't show it on the balance of probabilities on the material that's become available? To say that a policyholder wants a quick decision is not the same as saying they'd be happy to accept less recovery, because the question has to be answered before there's been the true facts have come out. We also say that the premise of all this, that there can be a quick payment for business interruption loss, ignores the terms of the clause. One can estimate the business interruption loss at an early stage, but you can only calculate it after the end of the indemnity period. That's because the calculation is by reference to the difference between the position in the indemnity period and the previous position. And that's simply a reflection that you may have a downturn in business during the interruption, and then there's a significant uptick as your shop's being closed and you have a rush of customers. You can't simply take the dip in customers, you've got to take the full period. And all that, again, one can see that from the definitions I took your lordships to, SB1, page 23, definition 9, and SB 32, definition 93. One's looking at the overall period to calculate business interruption loss. And you also can't obviously decide aggregation of future losses until they've actually occurred, because you may be able to guess or assume that they will aggregate back to the same event, but there might of course be a more relevant intervening event, which means that they don't aggregate. So, my lord, this assumption that you can do it on perceived facts is one that we say simply doesn't work. And the judge's exception for fraud or for facts which couldn't have been anticipated, we say creates a sort of recipe for uncertainty. How long do you wait? What counts as facts that you couldn't have anticipated? So analytically, we say it should be by reference to true facts, albeit in this case it doesn't make a difference. But what you can't do is what I think my learned friend tries to take from the point of construction, which is to say you should always prefer a construction which allows a quicker payment. Because as I said, this is a clause where, by definition, you can't get to the final payment until you've had the end of the indemnity period and you've been able to calculate the full loss. You can have interim payments, but that's not the same as calculating the figure. So, my lord, those are the points of law. In relation to I've taken your lordships to the single business interruption loss clause, and perhaps just go back to that quickly. It's page 33 of Core Bundle 1. It's supplemental. Sorry, I'm sorry, Lord. It's supplemental bundle 1, page 33.
Yeah.
And the quick points to note are that single occurrence is not a defined event, or not a defined term. It's clear that it doesn't simply mean insured event or covered event. The reason one can say that is, A, the more general one that aggregation is looking backwards, but also because this policy defines, for relevant purposes, insured event as a covered event, which one can see on page 23, and it doesn't use that term for the purposes of the SBIL. It's also apparent if one looks at the general conditions, general condition 8.3, which is on page 20, that this presupposes, this is 8.1.3, which says where a single business interruption loss is covered under more than one insuring clause only, one limit of liability, being the largest applicable, will apply to such single business interruption loss. And that obviously presupposes that you are aggregating across covered events. Your Lordship's already been taken and referred to the phrase. It includes the phrase in connection with, and we say therefore invites a wide approach to aggregation as long as a single occurrence can be identified. It is a clause which, this is a policy obviously which, as has been found, expressly included COVID-19, with diseases with pandemic potential with global consequences. And indeed, the judge pointed out in the VE judgment, I'll just give your Lordships the reference, CB, core bundle, paragraph 15, page 249, paragraph 25, that a lot of the diseases which are listed aren't endemic to England. So the implication must be that they're coming from somewhere else. They're coming from abroad. The policy also included wording which provided for a disease to be deemed notifiable and therefore an insured disease from its initial outbreak. And I showed your Lordship that in the context of the definition of notifiable diseases. Now, the judge said, and this is paragraph 156 of Stonegate, that it didn't assist because this referred to the initial occurrence, not the initial occurrence of a case of disease, but of disease generally, which was taken to be the 31st of December. So he's saying it's not quite the same as looking at a case of disease. You're looking at the deeming provision for when the disease first becomes notifiable.
Yeah.
But with respect, the point is a narrow one. And it's that in the specific context of this policy, and indeed of the disease clause, it was looking to circumstances outside the vicinity, so outside England or the UK, whichever it is, and looking to developments prior even to the period of insurance. Obviously what the divisional court said in that was it was deemed to take place in Wuhan, China on the 31st of December, which for some policies obviously would be outside the policy period. And that's what we say is the relevance. This is a policy that is looking to the outside. It's not trying to be any, it's no more sophisticated a point than that. It's envisaging a global consequences. Now, my learned friend in her respondent's notice says the wording simply a response to the Hong Kong Court of Final Appeal in the Harbourview decision, where the court there had held that loss wasn't unrecoverable until the disease was actually certified as notifiable, so deeming it to be recoverable from the time of original occurrence of the disease, therefore assists. But Lord, we say that doesn't undervalue the point at all. That may well be the explanation for the actual.
It is the explanation.
Yes,
I remember we had this came out in the Arch case at some point.
I mean,
but your real point is, so what?
So what? That's exactly it. I mean, I suppose I have 2 points. I have the point that Mrs. Justice Cockrell would make, and which she made in Corbyn and King, paragraph 178, which is historical derivations are relevant to construction.
Very interesting, but yeah.
But the more general point is your Lordship's point, which is that, well, so what? It points outside the vicinity. and it points outside the period of insurance, it is a reflection that this is not an insular policy. It is looking outwards. It also, in relation to non-disease perils, it's also clear that the actions of governments or authorities will be in response to something. So, for example, on prevention of access, if one goes back to 9/11, your lordships may recall that one of the consequences of 9/11 was a lot of the skyscrapers in Canary Wharf were evacuated. And again, if one were asking, why is there prevention of access to these various buildings or to these roads around these skyscrapers, one would say, well, because of what's occurred in the States. And from the perspective of someone in England, you'd probably say, well, that's one event. It doesn't matter that they are 4 separate events. From the perspective of the policyholder here, you'd see that as a unified event. If one's looking at enforced closure of premises for health concerns, and it's as a result of contaminated food getting into the food chain, again, if that is contaminated food which comes in a French cheese factory or it doesn't really matter. Again, the event which would cause the closures of the food premises or the cheese shops or whatever would be the original contamination, not the distribution. And again, it's pointing to the fact that it's agnostic as to where the event is. Now, Lord, if I turn then to the facts in this case and focus on the events in Wuhan, and in summary, the question is, was there a qualifying occurrence? Was the loss connected with that event? And is it too remote? All in the context of the clause, the correct perspective, and whether it's meaningful or significant. The judge set out the key facts, which we don't really need to go much further than that. I'll take your trip to 1 or 2 more points, but at paragraph 84 of his judgment, which is in the core bundle 15, page 260. In fact, it returns to page 261. So SARS-CoV-2 was probably introduced into the human population in Hunan market, Wuhan. Secondly, the ultimate source of the pandemic in the UK and globally was the outbreak of SARS-CoV-2 in Wuhan, China in late 2019. 4, an MRCA is not a fixed entity, but instead must be defined as a relative to a specific group of infections and is best understood by starting with this group of infections and moving back in time and following all the lines of transmissions into the past. And in that regard, 5, the MRCA of all available SARS-CoV-2 genome sequences was a virus in a cell in a particular infected host, and that infection probably existed around November, December 2019, and was probably an infection in an intermediate host animal, not in a human, and was probably located in Hunan market. But Professor Pipes thought there was a reasonable chance that the MRCA could have existed upstream in the supply chain, and therefore may have existed outside Wuhan, but there are no data at present that can support or refute that notion. And then jump to 7, to a very high degree of certainty, SARS-CoV-2 cases, etc., were not linked by a continuous chain of infection to the initial introduction in England, UK. Very large numbers of introductions seeded multiple independent transmissions in the UK. Professor Pybus gave evidence that there were at least 1,179 introductions, each of which was genetically distinct and created an onward chain of transmission in the UK. And Lord, just to complete that, if your lordships go to the supplemental bundle, tab 6, one has the agreed facts, page 102. SARS is a novel coronavirus. The disease caused by SARS is referred to as COVID-19. The COVID-19 had its origins in Wuhan, China. 3, the index case, that is to say the first recorded case in a human being, is a vendor in Hunan wholesale seafood market, whose illness began on the 10th of December. For SARS-CoV-2 has undergone and will continue to undergo mutations whilst existing in the human population. None of the mutations to date are a new novel coronavirus. 5. The human-human transmissions of SARS-CoV-2, which brought about sustained human community transmission, took place in Wuhan on a date before 31st of December 2019. All cases of SARS-CoV-19 trace their genetic heritage back to a single infection, either in animals or humans, which was the most recent common ancestor of all viruses known as SARS-CoV-2. Using a molecular clock analysis of that infection is consistently estimated for the first 2 weeks of November 19 with a range of statistical uncertainty spanning early October to December. And, my Lord, with those facts, I mean, there are, and I think we refer to the joint statement as well, that I think the reference to there being two lineages, A and B. There are at least 2 spillover events, two zoonotic leaps from an animal to a human, and that reference is at supplemental bundle tab 8, page 182, and that the relevant time for the spillover was most likely 18th of November to early December 2020, and that's in the Stonegate judgment, supplemental bundle 18, page 523, paragraph 134. It's also referred to in my learned friend Skeleton. Now, does it matter that we don't know the exact date or exact part of the market? Well, we say no, because we know in fact something happened in a specific place and in a specific time and in a specific way by zoonotic transfer or human transmission, depending on which you want to focus on. And Lord, if one wants to check what was known at the time as a cross-check, which is what the judge did, it's helpful just to look at supplemental bundle 2, if you want to have it still open. Tab 2, and there are some example press stories, so it was more, I think, for the court. Supplemental bundle 2.
2.
Sorry, my lord. Supplemental bundle 1, tab 2. Page 45. And we'll see is there a story. This first one is from CNN, 22nd of January 2020. Wuhan market at the centre of the outbreak remains tightly sealed. Page 46, Chinese authority scientists have pointed to wild animals, sorry, this is in the middle, as the likely source of the coronavirus outbreak that has killed 9 people and sickened 440, and referring to the spread. One turns over the page to 47, one sees a BBC article from the 23rd, a London-sized city where the virus began. One follows the page. The following page, just above the photograph. In short, the virus has spread so widely because lots of people visit Wuhan and take the virus home with them. Under the picture, Wuhan International Airport handled 20 million passengers in 2016 and offers direct flights to London, Paris, Dubai and other cities around the world. On the following page, one sees a map of Wuhan, including the Hunan Sea Market. And then on the page 50, so although the coronavirus originated in a local seafood market, the flow of people in and out of Wuhan has ensured its spread. And the point here is simply to make that it was well understood at the beginning what the source was. I know there have been other competing theories as to what occurred, but it was pointed very early on that this was the source. So from having the common sense check of, is what's being suggested at the moment something unrealistic, something no one at the time would have thought about? The answer is no, as indeed the judge found. The judge found it.
I don't know if it matters, but plainly at that stage, we didn't know what the experts are saying in terms of there being at least 2 spillover events and however many human-to-human transmissions, let alone, obviously, what happened in terms of transmission to this country.
Exactly. So, and the question is, what's the core? And it's come to my submission, which is the core is that there was emergence of a new virus in in Wuhan. The rest are proxies, you know, saying it's the last mutation which was being argued below, or the first human transmission, or the initial outbreak. Their proxies are saying the beginning of the story from the perspective of the reasonable policyholder is you know, one of those potential events. I mean, the other point to make, and we've given the references in our skeleton, so I won't take your lordships to them, but in the SAGE minutes, it was referred to up until, I think, including March, as the Wuhan coronavirus in the heading. It's sort of pages 57, the same bundle, pages 57, 60, 61, 65. And indeed, in the agreed chronology, which is in the core bundle, tab 12, again, there are multiple references to the disease coming from Wuhan in government statements, again, which are set out there. Now, coming back to that point just raised, one can put it in lots of ways, but we say that the single defining occurrence from the perspective of a reasonable policyholder is the emergence, the start of this novel coronavirus. Now, I emphasise the word novel, but this is very different from having a disease which has been around, which has re-emerged. There was a proper beginning in this case. There is a defining event. It's the fact that you had a new disease that not just made the zoonotic leap, but then was transmissible with all the characteristics that we had. And remembering that the judgment point, and this is, I think, an answer to my Lord the Chancellor's point earlier, of raising the judge's points about saying, well, there are lots of other events. But actually, by the time you're looking at that perspective, whether that's in March, February, March, April, May 2020, you know that's happened. That you know what the disease is. The disease is capable of doing so and has done so. And so those sort of potential future issues simply are no longer the meaningful explanations. The fact that someone got on a plane and then someone went skiing and they came in, those are not meaningful explanations for what occurred.
Just to be clear, does what you've just said, emergent start of novel coronavirus, correspond to any of your candidates?
So this is my point. So what we say, and the reason I put it like that, is to say that within that, you then have different options that you go for. You can say initial occurrence, and we say that is the best explanation for how a reasonable policyholder would have regarded it. You know, the initial occurrence of this novel disease. But you can use other proxies, and the reason I'm using emergence is to recognise that there are proxies for how you describe it.
And when you say initial occurrence, you mean first human infection?
Well, that in fact I think comes to the core of the question, because the judge, of course, took us to mean initial occurrence as meaning effectively what happened in Wuhan after it. We say that's not what we were focusing on. We were very clear in saying we meant the beginning. The initial zoonotic spillover is a human transmission. That's the beginning of the story. What happens thereafter, we would accept is not an occurrence.
So to be absolutely clear,
yeah, sorry, the initial outbreak.
Initials. Yeah. You focus on the initial spillovers. However many, between 2 and 15. It's not a spillover; it's that set of spillovers.
Yes, and the judge accepted that the initial human infection or infections, and the part I took your lordships to earlier, could be described as a single occurrence. And there's no appeal from that. So the judge accept, you know, it doesn't have to be one. And I think, to be fair, the evidence, if one looks at it, is that there were at least 2, but Professor Pybus wasn't clear whether there would be more than 2 or up to 15. There wasn't the evidence either way. There certainly could be more than 2, but there were at least 2 to explain the position. And the judge accepted infection or infections as being sufficient, but he rejected the point about initial outbreak. Now, we certainly accept that outbreak can be used in different ways. So you can have a chickenpox outbreak at home. You can talk about outbreak in a country, which is obviously a very different context. I think in our opening submissions below, which are in the bundle, supplemental bundle, tab 13, page 321, we give the Oxford English Dictionary definitions, which are of an outbreak being a sudden occurrence. You know, you can look at it in different ways. And we can understand that as a scientist, you may look at it differently from a policyholder. But what we were pleading, and indeed what each of the insurers were pleading, in this regard we're pleading the had the same pleading, was the initial outbreak. And so we say the sudden occurrence, not the spread of the virus. And I think we've given the references in our written submissions that in our opening submissions we were clear what we were focusing on. And we say that's no different from in Scott and Hope and Copenhagen talking about the war or the invasion. As opposed, it's the start of the story. You could have an argument as to what is the start of the invasion or the war. Is it the covert mission? Is it the declaration of war, etc.? But the core of what's meant, we say, is clear. Now,
If you're right about that, and you've got, as it were, an occurrence in the bag, do any of your other Wuhan candidates matter?
no.
Because presumably any question of remoteness, which would be the next stage in the analysis, would apply to them all equally.
Yes. No, so in my submission, we've put in the submissions in relation to how the judge dealt with the position in Stonegate and in Greggs, because he clearly accepted that the initial spillovers were a single occurrence, and indeed he dealt with them in Stonegate and in Greggs as part of the section of initial occurrence. And it doesn't appear that the judge was trying to take a pleading point by saying, well, by saying initial outbreak rather than initial spillovers, you've lost tough. He's really saying, well, actually, I think if you put it too widely, if you mean wide, that's not okay. If you mean narrower, that is okay. But in any event, you fail because of remoteness. That's how we would, certainly that's consistent with how he dealt with it in Greggs and in Stonegate. In our case, he dealt with it slightly more tersely because he simply said there is no initial occurrence. And so in that sense, he found against us on there being an initial occurrence. So, Lord, essentially it is dancing on the head of a pin, and we're making clear that initial occurrence is perfectly apt to include the initial spillovers. I mean, that is what we were focusing on, given the submissions. Now, whether that's enough is another matter. And Lord, I should say, just so your lordships have the reference on that, I think the judge essentially accepted that point, because in the consequentials, when we made this point about actually we were referring to something a bit narrower, and this is Supplemental Bundle 2, tab 21, page 630, he said, well, in that case, it doesn't add anything. So, Lord, we still failed on initial occurrence. I mean, there is a finding in the declaration there is no initial occurrence. But it does, in my submission, that is too narrow an analysis, given that the judge has found the initial spillovers do count. I mean, Lord, so your lordship's right that we don't really need to rely on the first transmission or the first sustained transmissions. I think all I would say on that is that they are clearly events in that they happened at a certain time, in a certain place, and in a certain way. And again, the real question becomes remoteness, subject to one point on the causal link. Now, the judge accepted the causal link for each of the occurrences. That we relied on. The my learned friend's respondent's notice, however, does challenge the causal link between the first human-to-human transmission and the first relevant human transmission. Doesn't challenge it in relation to initial outbreak or spillovers, but does challenge it on the latter points. Now, I obviously have the point that in a way I don't need to to succeed on these other points. If I'm right on occurrence, on initial occurrence, or indeed spillovers, then I don't need to rely on the initial transmissions. I would simply say...
I'm sorry if I'm being slow, but I don't quite understand why there is a declaration that there is no single occurrence when paragraph 92.1 says the initial human infections could be described as a single occurrence.
Well, that's my point, that in the VE case, the answer he gave and was debated was to say, well, initial occurrence, there wasn't an initial occurrence because he was referring it to more widely than we were, but he was recognising that the initial spillovers would have amounted to it. So we do say that there was the judge was simply too narrow in what he took initial occurrence to be, too wide, And if he'd accepted the way that we were putting it, which was as a narrow start of the story, it should have followed, given what he'd found about spillovers, that we succeeded on initial occurrence. That is our point on this. And I keep on saying initial occurrence, and my learned Judah keeps on repeating it's initial outbreak, of course.
And showing that I'm not keeping up, where do I find the declaration that there wasn't an initial occurrence?
Lord, it's in the
235.
core bundle 235. I'm very grateful.
And it's declaration 11, isn't it? 1, 2, 3, 4, and 6 do not amount to a single occurrence. No findings may be made.
And perhaps I just will take your lordships to what the judge said in Greggs, because your lordships perhaps have looked at Stonegate more than Greggs. Maybe that's unfair, but in Greggs, the way that the judge deals with it is interesting. It's in supplemental bundle 2.
Authorities bundle, perhaps?
It's also in the supplemental bundle, Greg's judgment. Paragraph 58 to 59. And as I said, all the insurers put it in the same way on this point. Zurich's case on the initial outbreak, page 587. The second heading under which Zurich's aggregation options are grouped is as initial outbreak of COVID-19 in late 2019. Zurich contends that the explosive outbreak of COVID-19 in late November or December constitutes a single occurrence. Insofar as this case is that there was a single occurrence in the zoonotic spillovers, which probably occurred in Hunan Market, I'm prepared to accept they can be regarded as an occurrence. Insofar as the case relates to the wider spread of the disease, I do not consider this as a single occurrence, but a number of occurrences occurring over a period of time. And then he refers to causal link in 60. So, I mean, our point on this is really very straightforward. We're saying we were running the narrow case. I have the backup cases on individual cases if necessary, but really I'm simply writing what the judge has already found on spillovers and says that must apply to the initial outbreak. And for your lordship's reference, it's dealt with in paragraph 142 in Stonegate, this same question of the initial outbreak. And again, makes the distinction between the initial infections and the outbreak thereafter. Lord, in relation to the question of causal link, as I was saying, the issue is really only in relation to the respondent's notice. And all I wanted to say, and the causal link is really only challenged in relation to the first human or the first relevant human-to-human transmission. I mean, for present purpose, I'm happy just to focus on the first relevant human-to-human transmission to bring about sustained community transmission. And we say by definition, if this is the first human-to-human transmission to bring about sustained community transmissions, it will have a causal link, be connected with, loosely connected with, the ultimate losses. And the judge was entirely right to reach that conclusion on the wide language of the clause.
Just to be clear, I forget exactly how you define relevant. Can you say, in relation to the first relevant human-to-human transmission, that it contributed to what happened in this country?
Well, I'm taking the simpler argument. There's a broader causation argument, which depends on potentially going backwards rather than forwards. So I'm taking the simpler one, which is saying if one is defining this as the first relevant human-to-human to bring about sustained community transmission, then we would say, to almost by definition, that is one that does spread. We're talking about the Hunan market, the initial story, and how that then affects the losses. Whether it's a big part of the story or a small part of the story doesn't really matter on the very broad language.
And how did you define relevant? I forget.
But to bring about sustained community transmission. So it's one that doesn't, because the argument that was made was the first case, which of a human-to-human transmission might have died out.
Yes.
Yeah.
It might not have been effective, and there might be a 70% chance. And so we say, well, if that's right, I mean, there's an argument that still calls it irrelevant because it has a common ancestor which causes the issue, but ignore that argument. Because one's defining it by reference to the one that gives rise to sustained community transmission, it will have causal relevance. I mean, it's no more complicated than that. I think that's why the judge, I suppose, correctly accepted it had causal relevance. Separate question whether it's the meaningful explanation, but in terms of causal relevance, that's sufficient on this very weak language. It's the beginning of the story in terms of human transmissions that actually go forward. So, Lord, turning then to remoteness, the judge considered that the events obviously were too remote as a matter of geography, time, and causation. And I do say that there was a striking absence of any standing back to consider what might be the most relevant or meaningful event. Merely saying, well, actually, there are other events, causative points afterwards, is not really doing that exercise. For two reasons. I mean, one is it's not recognising the nature of this clause, which is a wide causation clause. And secondly, the mere fact that you have lots of steps doesn't tell you that those are meaningful steps. And therefore, the absence of the standing back in the context of the clause, in the context of the perspective of the policyholder at the time of aggregation, we say is a key issue, because you can't consider remoteness in the abstract, but only by reference to the clause, the perspective of the policyholder, and the relevance, meaningfulness of the putative aggregating occurrence. Now, in terms of the policy, I've made the points, namely 3 points. As wide linking language. It's a policy that provides cover for pandemic disease, and it's reinforced by wording which provided for a disease to be deemed to be notifiable from its occurrence in China. In terms of perspective of the reasonable policyholder and what amounted to a meaningful event, this was a policyholder running a hospitality business, heavily dependent in many locations on tourists, and that's pleaded at core bundle, tab 20, page 336, paragraph 33. And as I've taken your lordship to, various eateries started to suffer their loss from the 27th of February. I think I gave your lordship an incorrect reference earlier on the 27th of February. That should be core bundle 19, core bundle, tab 19, page 298, paragraph 17. And we do say, if one had asked at the time, just shortly after the 27th of February, when losses started being suffered, what event is this all connected with? You're asking the policyholder, what event is this connected with? They would most obviously have said, the emergence of the new virus in Wuhan, i.e. the initial outbreak of the virus, or the first case of virus. And as we've seen, this was something that was known about at the time. It was known that it was connected to Wuhan. It was known it was connected to the sea market. This we say would have been the natural answer to the question that the clause requires you to ask, which is there a single occurrence to which this is connected?
Well, at that age, I suppose they might have given that answer, but the one answer they couldn't have given was because the government has closed all our restaurants.
Yes.
Because that
So
hadn't happened.
Exactly. So one does it in
But
stages.
if you ask the question later,
You asked the
you
question
might
on,
get a different answer.
asked the question on the 23rd of March.
Yes. And then then we would say that the government action over time is simply a reaction to that original event. It's not the most meaningful explanation for it. And the way to test that it's not the most meaningful explanation for it, in my submission, is first, there are lots of different events. And as we know, the government took multiple different steps. And that, when one stands back and says, well, does that suggest that in fact, when we're looking at government action and the lots of individual steps, they aren't really the most meaningful explanation, because they are all dancing around, dealing with a reaction, a mitigation of a problem. They aren't really the explanation. Just like, if the fire brigade, if there's a fire and the fire brigade, slightly damage your property as they're putting out the fire, you'd still say that, why is your property damaged? It's the fire. The steps in mitigation don't normally take away from the fact of the original, key event, here the emergence of a novel corona.
The true facts, taking your point about true facts from Justice Ricks and Kuwait Airways, and I follow your point about that. But you're looking at the true facts as they were at different periods of time. And my Lord's example of, let's say, for the sake of argument, the 1st of March, you're already suffering losses on this hypothesis. So the reasonable policy holder is asking the question, what is it that's the meaningful explanation for this? He might in fact say, well, it's because this disease is well on the way to being a global pandemic, and tourists have stopped coming here from all over the country, all over the world. So
that might not be an event.
How could that be said to be one occurrence?
Well, but that in a way that's the answer. Because the clause is requiring you to ask the question of is there an event. Now, if there isn't an event, well, it's easy. There can't be aggregation. But here we've identified, and the judge has identified, an event. The initial zoonotic spillovers, which we say is the same as the initial occurrence. Right. And so the question is that a meaningful explanation? We've got the point about prior to the government action. We've then got your Lordship's point, which I quite understand, which say, well, does that position not change? And of course it may change, but we say it doesn't change by lots of different steps of government action, which are simply mitigating the original steps, a bit like the fire brigade putting out the fire. Similarly, the Sweden example is quite a good one, because if one says, rationally, well, what's causing this problem? Is it government action? The answer would be yes. I mean, my restaurant's closed. But it would also be, but irrespective of government action, very few people would be coming to my restaurant because the guidance would be the same, avoid transmitting a disease. So although all my losses, some of the losses may have a relationship with government action, the most obvious explanation for it all, why am I in this position? What's the event? It's a novel coronavirus. It's a new virus that emerged. The initial outbreak, the key bit being that, it went from animals to humans and transmitted onwards. And that's the event. Whereas government action is diffuse. It's mitigatory.
And so is the development of the pandemic, isn't it?
Yes, more, but not the event.
It starts off in China, then as I recall, and I think we see it somewhere in here, it starts off in China, then it ends up in rest of Southeast Asia. Then it ends up in the United States, which is really where, as it were, the trouble starts. At which point, the American, I can't remember when the US closed its borders to aircraft from China, but it was about the 5th of March, wasn't it?
I accept all that, but again, that all becomes history. This is the process point. If you look at the question from the 15th of December, if someone had taken a swab and found some coronavirus, it would have been speculation. And your Lordship's point about, well, this could have happened, this could have happened. But in fact, all that actually happened was a highly contagious and very nasty disease spread naturally. There was no independent human act. I mean, one can well see that if someone had deliberately gone and spread it somehow, when it would otherwise have been contained, that somehow might become the meaningful event, or at least take away causative potency of the original event. But in the case where all that it is a disease with certain characteristics is unfolding, it's difficult to see why any of that unfolding, spreading through aircraft, spreading through governments taking mitigatory steps, or being slightly slowed down by it and disease going around the corners to avoid them, how any of that can be regarded as depriving the original defining event, or key event, or meaningful event, of its relevance. Now, of course, we accept it doesn't continue indefinitely. As a meaningful event, it will become too remote. Its relevance as a significant event will disappear. And the most obvious time is if the disease abates such that it no longer has any relevant continuing impact and then comes back. Well, clearly one can see that one wouldn't say the original event has any meaningful explanation anymore. But here we're talking about a policy period that stopped before second lockdown or anything like that. The period here simply covers off up until the 28th of September. Now, Lord, in terms of the specific points that the judge raised, on causal connection, we've made the point that the parties chose a weak causal link, and you can't therefore use that as a reason to say, well, it's causally more distant, and that dismisses it without more. And the more is whether it's meaningful or not. It was simply the disease spreading and no contingent event. And I've given your lordship the example of the firefighting and etc. In terms of timing, this was a new virus, a new disease, and in fact what's remarkable is how short a period there was between its emergence in the Hunan market and coming to these shores. And there was no reason in principle for any of the steps that intervened to stop it being the meaningful event. And in terms of geography, I mean, it is, we say, a simple point. I mean, this is, Wuhan was a major international city, or is a major international city, as you've seen from the BBC article, frequent, direct travel links. And the idea that the spread of a pandemic disease around the globe is too remote in such situations, we say is not a good one. It's all context specific. This is a case where geography doesn't mean anything. And if we take an example, let's say various eateries had ordered some plum sauce from Wuhan, China, from their regular supplier. An employee contaminated the batch of plum sauce, and it stays in Wuhan for a few months before it's shipped over. It takes, I think, a couple of months from Wuhan to get to England. There it perhaps sits again, goes through customs and health declarations. Decisions are made as to which plum sauces to put on tables. Customers decide whether to open them or not open them. So geographic, a big difference. Time-wise, there may be months, 6 months before anyone starts opening these jars and starts getting ill. Would that be too remote to say that the relevant event here is the original contamination of the plum sauce in Wuhan? The answer is no, because although there are plenty of steps, shipping, exports, opening, time, it's all in the normal course. There's no relevant intervening act. The geography or the time or the causal steps don't affect the point that the meaningful event is the poisoning or the contamination. It's the most meaningful explanation for the plurality of losses which can be given. And we say that...
Well, that's because you have a disease or a poisoning which is attributable to the original malicious act in Wuhan, in your example. Whereas if you caught COVID, then you got it from somebody else in this country or from having travelled abroad or whatever.
Yes, but even in the
plums... your having caught COVID was itself caused by the initial outbreak in Wuhan.
But there's always an extra cause. You've been taken to the restaurant, someone's decided you should have plum sauce, the waiter suggests try some plum sauce on it. There are always extra elements, but all the disease is it's the beginning of the story, and then it spreads as the disease, not with any extra intervention or any extra steps. It just spreads as the disease. None of those intervening steps of mitigation, we say, affect that essential point.
Yeah.
The secondary point on all this is if we're wrong about Wuhan, and your lordships conclude, well, no, it is too remote, or in any event, that the secondary case is in relation to the introduction to the UK, and that means the initial cases or the first transmission, and the questions are: is there an occurrence? Is it connected with a loss? And is there an absence of remoteness? Again, in the context of what's meaningful, we say. Now, on the question of occurrence, I'll take that very briefly. We'll say, clearly, what is the first case to come in, or the first introduction, is an occurrence. It's something that happens in a time, place, and way. The judges, and I should say, the judge didn't answer the question whether it was an occurrence, because he went straight to causal relevance and to the question of remoteness. Now, in terms of causal link, obviously the big point against me is to say, well, actually there was multiple seedings. You can't just say that first case, was the source of everything that happened afterwards. And our point on this is really quite straightforward. It is to say that if the Supreme Court, as the Supreme Court say, I was about to say if the Supreme Court are right, but they are right, of course. If, as the Supreme Court say...
They are the Supreme Court, that's why they're always right.
each of the cases of COVID were an equal and effective cause of the public reaction and government action, therefore satisfying proximate causation, then they must necessarily be a sufficient to satisfy the weaker causal test of in connection with. In connection with being weaker than proximate cause, you must satisfy that requirement. Now, it's really as simple as that. What the judge then goes to say, in my submission, is a core point, which is to say, but that, even if that's right, it's still not a meaningful explanation. And here the judge does refer to me.
Just before you move on to the meaningfulness, and without regard to the expert evidence, which I haven't mastered in this respect, but going back to what I sort of remember, there were initial big news stories about somebody coming back from somewhere with the infection.
Yes.
Possibly he passed it on to some other member of his family, but it was all contained.
Yeah, that was the lady from China who,
Yes.
who gave it to her son at the University of York.
So the first transmission within the UK wouldn't have gone anywhere because it was contained.
And then there were all those people who came back from skiing holidays in Austria and Italy.
Precisely. But
who were
remember,
said to have
what we're,
spread it all over the place.
what we're talking about now is the causative relevance of the case to public reaction and to government action, not to creating another case, but to public reaction and government action. And the Supreme Court held, well, actually each of those cases was an equal and effective cause for the government reaction that followed. Yeah. So we say, so on stage one, we say, well, if that's right, it just must follow as night follows day that they satisfy the causal requirement. It's separate whether it's meaningful. And because there the judge said, well, it's not meaningful because there are lots of them. Why would you point to one rather than the other? And our answer to that is really a very straightforward one, which is to say, if you're looking at it from the perspective of a policyholder, of what is a meaningful event, and you've got a list of, here are your options, and that includes, the first case in England, because, that is an occurrence. It happened in a way, a time and a place. You say, well, actually, that does have meaning, because what that case reflects is the disease coming to England. So having been abroad, now this disease, which has been spreading everywhere, has come to England. And that's why it has a meaning, it has a particular meaning. That the introduction, whether one puts it that way, or the first case has meaning, irrespective of whether it dies out. Because it has a causative effect on public reaction and government response.
But there's also an issue. I mean, I follow all of that, but there's also, and you talk about true facts. I mean, one of the potential true facts is that it was already here, long before the lady from China arrived on her plane. And indeed, I think that Professor Sir Chris Whitty said as much last week in his evidence. Now, he may be right or wrong, of course, but he was making the point that there was actually coronavirus in this country. Probably, I think he said in November or December of 2019.
I don't think he was saying.
How do you address the fact that on the true facts, if you like, it comes in many times from different locations and has a different impact. Sometimes it leads, as my lord said, sometimes it's limited to one family. Sometimes it leads to whole villages or towns.
It's the two stages. So you've got the first stage, which is, are they all causally relevant? I've dealt with that. The meaningfulness notion of it is an abstract question. What the policyholder is asking themselves is not, was it on the 15th of January or was it the 31st of January or the 12th? It is a notion of, well, what to me is the meaning? What would be the key event from my perspective here? It's the disease coming into England. And that person may not know, and it may change over time as information changes, when that first case was. But that doesn't alter the fact that that's what represents the sea change. If we're wrong about Wuhan, and so the policyholders have been told you can't look at Wuhan because it's irrelevant for other purposes. So you then ask the obvious person, well, what is it that caused the issue? Well, it's coming into England. And of course, I'd have a much easier case if it was only one case coming in, and everything spread from that, and one might say that would be a very clear defining event.
It sounds as if what you're really driving at is the breakthrough into public consciousness that coronavirus is here, which I don't know if that sounds like an event or not.
But no, but that's the point. The event is the event, but why it has meaning is the public consciousness aspect of it. That, you know, what is it that is, you know, why is one event more important than another? Because that's the question the judge asked, which is a fair question. It's because it's the beginning.
But the trouble is, in terms of public perception, thinking back, I think what really mattered was when you got the impression that it wasn't contained.
Yes.
So we can't identify that event exactly.
Well, I mean, this comes back to the point that obviously one can identify different points in the spectrum. I mean, that's why we say that Wuhan is so attractive, because it is a clear beginning, and it is when one asks a policyholder to think it through, and, you know, in an applied way from where you are, what is it most related to? Wuhan, we say, does become the obvious example, because yes, there are issues with everything else. We say there are real issues with government action for the reasons we've given, that, you know, normally mitigation isn't regarded as being the relevant event. There are lots of them. Is that really how, you know, if you'd ask them, you know, what does this really come out of in the context of an aggregation question, which is what all of this is about? So we do say that, you know, it has a significance, a bit like the opening shot of, you know, the American Revolutionary War, you know, the shot that rang across the world. You know, it's not that that shot in fact has any more causal relevance. There were plenty of other shots afterwards. It would probably have happened afterwards, but it symbolises the beginning. And that, in a way, is what the first case of the introduction does. It symbolises that start, and that's why one has the relevance. Even if a virologist would say, well, actually, that's not much of interest to me, whether it's the first case or not, because it would have come in anyway. That's, again, perhaps an example of where it differs as to whether you are a policyholder or not. Lord, I think I've got 1 minute more before I finish on to my second round of appeal. If you
Well,
want
why
to.
don't you finish the
Yes.
first round then?
And my Lord, in relation to remoteness on these introduction to the UK argument or first transmissions, obviously they're closer in time and geography. I think the judge accepted geography, but still said they were too remote as a matter of time. And we do say, well, that is making it really much too strict, and in a way underlines the almost mechanistic approach of saying, well, you know, it's government events are closer, therefore let's apply the government events rather than the what we would say are the better, more significant explanation. So, in summary, if we ignore Wuhan, we say it's the introduction to these shores, or the first transmission of these shores, which becomes the most meaningful explanation. It's because it indicates it coming home. Lord, I've got, I think I'm on time. I think I've got half an hour this afternoon, and I'll finish off the second round of appeal, which is
Well, that's a relatively short round.
which is a very
Very well, 2 o'clock.
All rise.